I'm going to hand it over to Laura Akins, who is an attorney with Nadler Biernath.
Hi, everybody. So we have a fairly small group today, which is kind of nice because hopefully this can be particularly helpful to all of you here. Like Brian said, I'm another attorney with Nadler Biernath. If you joined in last time, you heard from Heather Nadler, who spoke about kind of just what guardianship is, when is it necessary, those kinds of things. And so today I'm talking about the kind of the literal process of obtaining guardianship. How does that work? What do we do to do that? Like Brian said, I'm totally happy to take questions during my little spiel here. So either feel free, again, because it's kind of a small group, feel free to post it in the chat box and I'll be paying attention, but also I think it's, I mean, I'm fine with you just unmuting yourself to ask the question and then remuting. So I'm gonna go ahead and share my screen and we'll start with a PowerPoint, and then what I'm gonna do is once we get to kind of a certain point in the process, I'm gonna actually pull up the petition itself. I'm hoping that will be easier for you guys to read. Before I get going too much here, I wanna just give the full, standard lawyer disclaimer that this isn't legal advice and you should consult with an attorney for legal advice, but hopefully this will be very educational for you. Okay, so like we talked about last time, and we have some serious graphics for you here. Hopefully it'll keep you engaged. Georgia has guardianship, which is, here's the standard for what you need to meet guardianship. And it's when the proposed ward cannot make or communicate significant responsible decisions concerning their health or safety. We bifurcate the role of kind of the overarching guardian to say that the guardian is going to be over the care of the person, right? Over the health care, living arrangements, all those kinds of things. We also have conservatorship in Georgia, and that's when we need somebody to help manage assets, right? So in this case, the proposed ward cannot communicate significant responsible decisions concerning their property. And property can be a bank account, be any kind of money. And these standards that are on this slide here, this is what we're proving to the court when we are requesting that a guardian be appointed. So it's our burden to prove this to the court, right? Just like with any kind of legal proceeding, the court doesn't have any stake in this game, so to speak, right? We're the ones who have to show the court that this is in fact necessary. And so that is why there's a petition, and you have to kind of go through the whole process of getting the court the information they need. So again, kind of the deal here is that when we have a guardianship petition, we're going to have the proposed guardian or conservator, guardian and or conservator, I should say. That's usually one person. It can be two, who would serve as guardian and or conservator over a person who needs some extra help. Then you have the proposed ward. So the ward is going to be the person who needs a guardian. There's a petitioner. There can be two petitioners, as we'll see in a minute here. The petitioner is the person who's asking the court to grant the guardianship. The petitioner and the guardian, the proposed guardian, can be the same person. They can also be different people. And then that's in our petition. As a kind of part of the process, once we submit the petition, the court will appoint an attorney for the proposed ward. And they will also appoint sometimes a guardian ad litem, which is another attorney. Usually there are only two court-appointed attorneys in pretty limited circumstances. There will always be an attorney appointed for the proposed ward. The guardian ad litem is a second attorney that comes in sort of pretty narrow circumstances, but occasionally. The court, of course, is a player here, right? So there will be the judge who will be involved in making the determination about whether guardianship is appropriate, and the clerk, right? So in all of the courts, we have these clerks who are accepting the petitions that you're submitting, They are going to be kind of processing through all of this and then ultimately getting you to the finish line. So whenever you're dealing with the court, in all cases, you always want to be very kind and patient to the clerks because they're your friend. And then the last person is the independent examiner. This is the person who's going to do an evaluation on the ward. And that will happen in every case whenever we do a petition for guardianship over an adult. There will be a person to do an evaluation, and that evaluation is submitted to the court kind of as part of the evidence gathering process of guardianship. Okay, so when filing a petition, the court, like I said, is going to be looking to the petition for evidence, right? They want to know what's going on. Something else that's very important to know is that once we file the petition, along with getting the court-appointed attorney appointed and having the evaluator appointed, the court will serve this document that you prepare to or on the proposed ward. We have the sheriff will serve. In DeKalb and often in Fulton, it's actually usually a private process server, but it can be a police officer. It can literally be a service of a document. And so if your child, for example, if you're doing guardianship over your child, if you think they would be alarmed by having a police officer show up to your house, this is something to be aware of and to consider, because you can't always have a private process server do this service, but that's usually well, again, depending on what county you're in, it can be an extra fee and something you have to actively ask for. The other thing is, when we file the petition, the petitioner is the person who's responsible for paying the filing fee. And unfortunately, with guardianship and or conservatorship, they're expensive petitions to file because there's that court-appointed attorney and the evaluator, and it's just kind of a process. So the filing fees range county to county, depends on what county you're in, but they average somewhere in the range of about $500 to $800, just depending on what county you're in and their deal. But again, even $500 is hefty, and that's something to be aware of. There are some ways to file for assistance from the court, and that's something that you can explore with your court. Sometimes they'll grant that. Okay, so getting started, how do we, get this deal going in the first place? Any interested person can apply to a probate court for guardianship or conservatorship. When we say interested person, literally, I mean anybody who has a relationship with the proposed ward. So of course, family members are there, friends, somebody who is actively involved in the person's care, anything like that. We have on here, you must have 2 petitioners, or you can have 1 petitioner and a doctor's affidavit. We highly, highly recommend doing the 2 petitioners. You can have mom and dad be petitioners. You can have mom and grandma. You can have 2 siblings. You can have 2 friends. Involving a doctor and getting the doctor's affidavit is usually more expensive, and also just it's an effort because you've got to get them to fill out the proper form from the court, and it's a whole thing. So instead, again, remember the petitioners can be the same people as guardian or different, but we recommend having 2 of those. And then the other thing to just know is that this is a form. So the guardianship petition is a form. It's not rocket science. It's at this link here on the slide, and it's form number 12. And again, it's not rocket science. There are some nuances to knowing how to fill out this form so that you have an easier process, I should say. We are finding with COVID, it's been slowing down courts a fair amount, and it still is. There's a pretty big backlog. With guardianship, courts have a significant interest in getting this done as quickly as possible. Technically, when you file, they're supposed to schedule a hearing after 6 weeks after filing. Again, they got to take care of all their business in that 6 weeks, right? So they've got to appoint an attorney, they've got to appoint the evaluator. The evaluator has to do the evaluation, submit their evaluation report. So some things have to happen in that 6-week period, but you're supposed to have the hearing scheduled after that. We've been finding the hearing is sometimes more like 8 weeks, 8 weeks out, sometimes even a little longer than that. So courts are moving a little bit slowly, and they require, in order for it to be an easy process, absolutely you have to use this form, and you want to fill it out so that the court can just take a look at it and get what they need and move on to the next thing. So here's where we've arrived at the form. And so I'm actually going to change the screen sharing so that I can show you the form, and we have kind of a guide for how we want to put information into this form. So what you're looking at now is the petition. This is the petition you can see for appointment of a guardian and or conservator for a proposed ward. Even if you're just doing guardianship, even if you're the person that you're applying for guardianship over has no money, you're still going to use this form. Okay, so they've got instructions. All of these things are basically kind of summarizing just what the deal is, what's going to happen. And then we arrive at the kind of the first page of the petition. Hopefully you guys can all read this read. This document, Focus has access to it, and so you can ask for a PDF if they haven't already sent it out to you, and you can get this and be a little easier to read if you're looking at a cell phone or something. Okay, so we start at the top. We're going to be in the probate court in the county where the ward lives. So if you're applying for guardianship for your child and you live in DeKalb County and your child lives in Fulton County, then you're going to be applying for guardianship in Fulton County, because that's the county that has jurisdiction over your child. The name of the proposed ward is going to go here, and we want to do the full name as it would match a state ID or birth certificate. Kind of keep in line all the records so that you've got some consistency there, because this is a permanent thing and we want to make sure that it all aligns. The estate number is something that the court is going to give you after you file this petition, so you'll leave this blank. Ultimately, it'll be a reference for the court and for you in the future, so that'll be something they'll give you, an important thing to kind of just note. Okay, so if you're not applying for conservatorship, we often just kind of recommend crossing this out, literally a line through it, because it's just more specific, right? If you don't do that, if you didn't cross it out, it'd be fine, but something to do. And then here's where we really get started. So this is the petitioner 1, and this is petitioner 2. You would put the full name, again, kind of aligning with a driver's license or social security, something like that. List the relationship of this person, and again, you can see it's really, as long as they have a relationship to the ward in some way, that's what you would list. Domicile is going to be where the person is living, and then their mailing address is where their mail comes to. If the domicile is the same as mailing address, list them twice, list the address twice. Just again, so that the court can look at this and say, okay, that's the address that I need. Same thing for the second petitioner, same deal. You'll put their full name, their relationship, address, and mailing address. If for some reason you don't have a second petitioner and you're uncomfortable with the idea of asking someone to do that, and you want to use the doctor's affidavit, then you would put NA here, and you would initial next to the doctor's affidavit down there at B. If you don't use the doctor's affidavit, then you can, of course, put NA. Okay, so Cindy's asking, can I put my address for my second petitioner's mailing address? If that's their mailing address, I would put their mailing address for whoever the second petitioner is. Just because the court, so the idea there is the court may want to communicate with them, and you're telling the court there's a page I'll show you that everything is accurate. And so I suppose theoretically, you can get the communication to them, but I would recommend just putting their mailing address.
It's just that my older daughter will probably be moving in the middle of all of this, and so I don't know, I wouldn't know her mailing address.
Yeah, so in that case, if you feel like she doesn't have kind of a mailing address, right? She's in transit, then that's fine to put your mailing address. It's one thing if you're trying to say like, oh, I just want to, it's more convenient, I can kind of control the process. That's, yeah, but what you're saying, I would put your mailing address in, that's fine.
Okay. And I have a question about conservatorship. If my younger daughter has a bank account as well as a special needs trust, do I need to be her conservator as well?
We'll get to that, but the answer is yes, right? So we'll get to that in the petition. The answer is yes, because of that account, because of the bank account, right? The special needs trust is not a conservatorship asset, but the bank account is.
Okay.
Okay. So moving on. So we've got our 2 petitioners or 1 petitioner and a doctor's affidavit. Down here we get to information about the proposed ward. So again, full name and match whatever name that you put up here at the heading. Want to put the same name down here. The age as of filing, their date of birth, and something just to note, some people, you can file a petition for guardianship up to 6 months prior to the age of 18. So if they're 17 when you're filing this, then put 17, right? But the court will be able to see when their birthday is, and they'll be able to work with that. You have to list the social security number. So I know that's of some concern for folks, but you got to do it. The domicile, again, is where the proposed ward is intending to reside. So whatever their address is there. Where are they presently located? So in some cases, we have a ward who is living, maybe they're in a facility for some reason, but they are there for a short period of time and then they're going to go home, right? But if you're filing this petition and at the time they're located in that facility, then that's what you would list, right? Otherwise, you can say home or whatever it is. And then you would put the phone number for reaching the proposed ward. Now, many times a person who is going to be under guardianship doesn't, maybe they aren't able to speak on the phone all that well, maybe they just don't have a phone, in which case, again, it's the phone number to reach them, right? So where can someone call and say, I'd like to try and speak with this person? So that could be your phone number, that can be, you know, whatever phone number it is. Okay, so Suzanne's asking, how do you know when to file? Is it by county? So it's a rule across the board in Georgia that you can file for guardianship, again, as soon as 6 months prior to the age of 18. But then after that, there's no statute of limitations on any of this. Pretty much any time after the age of 18, you can file this petition for guardianship. So there's no, you don't get cut off after a certain age or something like that. It's just that you cannot file it before 6 months before the age of 18. Okay, so then the court down here is asking, will the proposed ward be moved in the next 3 days? And are they a citizen of a foreign country? It's just yes or no. Almost always or often, that's going to be a no for both of those. If it's a yes, then you just want to explain down below why it's yes. Then we keep going here. Is guardianship necessary because the proposed ward lacks sufficient capacity to make or communicate significant responsible decisions? Is conservatorship necessary? So first of all, you can see this is asking, is a guardianship necessary? And then B is saying, is a conservatorship necessary? So almost always we're doing this because of guardianship, so we would hit yes here. If a conservatorship is not necessary, then you would hit no, and you just want to put a little asterisk and say, this is the deal. You can see right here, we've said the proposed ward owns no property and has no income other than SSI benefits for which his mother has been appointed his representative payee. Obviously, that could be father or whoever. But that's just a nice place to put that in there. A person who's receiving Social Security benefits already has oversight from Social Security through the representative payee process. So we don't have to get conservatorship just for Social Security funds, right? If that's the only money, the only income that the person is getting, then that does not require a conservatorship, okay? All right, so then we get down to really kind of the meat of the petition, and this is going to be paragraph Well, so the whole thing is paragraph 3, but this is really it. So I'm actually going to share another page here. And I've got some samples of language for paragraph 3. So as you can see, these are pretty lengthy paragraphs. I'm just kind of scrolling through so you can see the link. Again, we will provide these to you so you can have them. But you can see we start off these paragraphs by saying the proposed ward, comma, and we give their name. And then we kind of say, you can see at the very beginning, we say the proposed ward, Jeffrey Smith, Jeff, right? So then we can continue referring to Jeff, and it's just an easy way to kind of reference Jeff or whoever. We start by giving their diagnosis, if there is a formal diagnosis. We usually explain, okay, where are they in their educational process? Guardianship is all about explaining to the court your child's limitations. So this is the tricky part. It's very difficult because as parents, we've been advocating for our kids. You've been working very hard to, get services and take care of your children. Here, we actually want to do the opposite. We want to show the court what are the limitations, why is this necessary. So we definitely want to provide any kind of information about their medical situation in general, certainly diagnosis, how it manifests. We want to provide information about whether they were in a special education program, were they receiving an IEP, what are they doing now, right? So if maybe your child is 22 and they've transitioned out of the school system, are they working? Are they in a supported work environment? Are they able to work at all? Have they maybe tried working and it didn't work? Then we want to tell the court more about this person, right? So things like how are they able to communicate? Can they communicate their needs? Can they communicate if they're hurt, if they're sick? If a stranger comes to the door, if they encounter a stranger in public, that may be, a little sketcy. Also things like, are they able to be left alone at home? If you aren't comfortable leaving them at home alone for, maybe more than a few hours at a time, why is that? Tell the court why that is. We also want to explain to the court issues with toileting, with bathing, brushing their teeth. A lot of times folks need reminding to actually use soap to brush their teeth or toothpaste to brush their teeth or soap to wash their hair, right? They jump in the shower, they do their thing and jump back out, but they're not actually using any soap, right? That's something that we need to tell the court about. And then other things we always like to kind of break down are their healthcare, right? So could they talk to a doctor and explain to the doctor what's going on with them? And then have the doctor say, okay, here's what you need to do to take care of yourself. And then could they follow a course of treatment? Could they manage medications? Could they go pick up medications? All of these things are things the court's going to want to know. And then the last thing I always like to talk about is, let's see, I'm trying to see if we've got any. I always like to address this one down here, kind of talks about it. First of all, vulnerability is a big thing nowadays. So I always like to talk about that piece of it. Sometimes online vulnerability has become an issue. Certainly things like being in a public place, are they going to be safe? And then also just the ability to handle money. Of course, that's going to be more of an issue if conservatorship is in play. But in general, if a person can't distinguish between the value of a $5 bill and a $20 bill, that's something we would want to share with the court. If a person, would go to Target or somewhere and pay $100 for something that should have cost $5, that would be something to share with the court, things like that. So we want to give some pretty tangible examples to the court. We want to give them as much information as you can. We're not looking for just my child needs a guardian or this person has some limitations and so they need help, right? We're looking for some specifics on why. And so that's where this paragraph comes into play, okay? Okay, so let me go back to the petition itself. Okay, So that's paragraph 3, and you can say see attached, or you can plug it in there. It's up to you. It's sometimes easier with the formatting on all this just to say see attached and then attach a paragraph. All right, so paragraph 4 is where we say who is actually going to serve as the guardian, right? So remember, the petitioners don't have to be the guardian. So we're saying the name of the person that will serve as guardian, and then if we're going to do a conservator, the name of the person who will serve as conservator. That can be the same person. It can be 2 different people also. All right, and then we would say that the incapacity is permanent. If it's not permanent, you want to think a little bit about whether or not we're applying for guardianship, and you would have to show, here's why I'm doing this, even though it's not permanent. You know, we've had some circumstances where we've had young people with traumatic brain injuries or something like that, where we're not sure about the person's recovery. So we would put them in there. I see your question, Debbie. I'm going to finish this thought and then we'll go back to it because that's a good one. So in here, the other thing just to note here is that the rights taken away by a petition for guardianship are going to be the right to enter into a marriage, enter into a contract, the right to determine where to live, the right to consent to medical treatment, and the right to revoke a revocable trust. They keep some rights. So things like the right to refuse treatment, technically a person can still do that, right? The doctor's not going to strap them to the table and shove a pill in their mouth or something like that. The right to independent legal advice is maintained. The right to contest a guardianship is always there. The right to vote is always there. You can also specify keeping the right to vote. This has become kind of a hot topic because, you know, we've got some misinformed voting officials or people who are working at the polls who get thrown off by this. So if you wanted to include it, you could. The right to make a will is not lost, though you have to have capacity to make a will. So there's sometimes a little bit of gray area there. And the right to participate in decisions concerning a person who's under guardianship. Now, something that people are often asking about and that comes up now a lot is that we have these post-secondary college programs, and those require certain rights to be kept. And so we want to make sure that if that's something you're contemplating, a post-secondary college program, you would want to keep those rights. I'm actually going to switch to the screen so you can just see this really, to the slideshow, so you can see this really quickly, because we've got a slide that includes all of those rights that you would want to keep if you're looking at a post-secondary program. Okay, and so this is the slide. They're sort of, well, you'll see. So this is the first one is consent to adhering to the applicable student code of conduct. The next one is selecting the course of study. So the person has to be able to do that. And then consent to being photographed and to participating in research conducted by the inclusive programs. So that's something that you would want to include. I don't think it can hurt to, you know, to include that if you think that's a possibility. If your child is not in a place where a post-secondary program is a possibility, then you don't need to include that. And then of course you can see, and so I think you'll have access to this slideshow, and I'll just kind of go back so you can see the rights not lost, and then the slide prior to that were the rights that are taken away. Okay, so let me go back to our guide. And the question that we had on this paragraph 4 is, can more than one person serve as guardian, mother and father? Can an older sibling be listed as a guardian as well? It's a loaded question because my thought on all of this is you should have one guardian. You can absolutely list co-guardians, we call them. So mom and dad could serve as guardian. I do not recommend listing a third, and you can't list a backup in this case. There's just no infrastructure to have a backup person listed, though that's absolutely important. Planning within your family to be thinking about who will be able to step in and are they aware of all the things that are going on here. The reason why I don't like the co-guardians is because that means they are truly two guardians as one. And so if something needs to be signed, both people got to go. If something needs to be agreed to, both people have to be there. And frankly, it's just a convenience thing. It's just harder sometimes to be able to get everybody in the same place at the same time when a decision really needs to be made. So it's ultimately up to you. We do oftentimes both parents just really want to be involved, and so we certainly respect that and we'll do that. But I wouldn't recommend if you can avoid it, or if it's something where you don't feel super strongly about it. Okay, so paragraph 6 is another question where another paragraph where people have questions all the time. As another sort of mode of oversight for making sure that the guardianship is appropriate and the right thing to do, the court requires that we notify 2 people. And there's some specifics as to how we notify 2 people. It goes in priority. So if there is a spouse of a person who's going to be going under guardianship, they would be first. And then all adult living children who have addresses that you're aware of. And so adult would be over the age of 18. And that would be the 2 people. And so if there were 3 adult children, for example, then you would notify 2 of those 3. If there's no spouse, no adult children, then it's just 2 people who are in the following order of priority. So lineal descendants of the proposed ward, so that could be grandkids, it could be, it would be probably would be grandkids, which may not kick in, parents and siblings of the proposed ward, and then friends of the proposed ward. So if you, in some cases, many cases, we've got an 18-year-old who their parents are applying for them to be under guardianship. And in that case, we would notify any adult siblings that person has, because both of their parents are the petitioners. And if they have no adult siblings, then the parents will select 2 kind of friends of the family that are familiar with the situation, and they'll list them here. You've got to have the name of the person, the age, and you can just put over 18 if assuming they're over 18, and then their mailing address. And you do not want to do a PO box here. You need to have a physical mailing address because the court's going to want that for certified mail. They want to make sure that the person can get it. And then their relationship, right? So just however they're related. All right, so I'm going to pause because Angela has asked, how does guardianship pass if a guardian dies? And so this is another reason why we don't recommend the co-guardians, because when you get guardianship, you get something called letters of guardianship, which is the formalized document that appoints a guardian from the court. And if you're co-guardians, then you've got letters of guardianship that put Mike and Nancy Smith as guardian. And if Mike passes away, you've still got letters of guardianship that list 2 people. So Nancy Smith still has to go to the court and remove Mike's name as the guardian. So instead, let's say that Mike says, okay, we shouldn't do co-guardian, then Mike is the only guardian. When he passes away, then Nancy would come to the court. And instead of doing this whole petition for guardianship, he would apply for, Nancy would apply for a petition for successor guardian. And so the way that works is it's a simplified process. It's not entirely simplified. It's still, you still have to file something with the court, but you don't have to do the evaluation. You don't have to do quite the same rigmarole because the court has already found that this person is incapacitated. So this document that we're talking about, filing this petition, the court's doing 2 things. First, they're determining that a person is incapacitated and such that they require a guardianship and or conservatorship. And then they're also determining who is the best person to serve as guardian. So the first thing is done and it's permanent, right? So once a person is determined to be incapable of making those substantial, important decisions about their well-being and maybe their assets, then that's decided. So in any case, when a guardian passes away, some action has to be taken, and usually it's filing with the court. And so that's part of the kind of planning process, having a cohesive estate plan, frankly. I mean, that's something we're always talking about with our clients who have kids or other folks under guardianship is, have you made a plan for what will happen when you pass away? And really the plan is just to inform people, this is what's happened, this is what I've done, this is what you need to do to take the next steps. All right, and then Cindy asks, if I'm the petitioner, then these two notified folks should not include me, and that's correct. If you're a petitioner, then you aren't going to be listed in this, this section here. Okay, and so then the next part is, was the individual nominated to serve under a living will, durable power of attorney for healthcare or other instrument? What this is asking is, as an example, when we do wills, we include a designation of guardian for our parents who have children who may need a guardian. And so that will becomes evidence if the parent passes away. So let's say a sibling of this, this person who needs a guardianship is trying to apply for guardianship. They would show to the court, hey, look, my parents said that I was the best person to serve. If that doesn't exist, if a financial or a durable power of attorney for healthcare or a will doesn't exist, then you hit no, but otherwise you would hit yes, and you would want to attach that. And of course, if that exists, that would need to be included. And then this question is, was an individual nominated in writing to serve as guardian of the proposed ward or any other individual? And so again, you just want to answer that honestly, depending on the circumstances. Same thing here, was an order relating to cardiopulmonary resuscitation issued by the proposed ward. This is going to, this is just information to the court, and almost always it's going to be no. Was a trust created for the proposed ward? So very often in our case, we have clients who have done a special needs trust. And so we want to hit yes, and the parents of the proposed ward have established the special needs trust. Inter vivos means a living special needs trust. So if you have a trust that you've signed on the line and the trust exists now, that's going to be an inter vivos trust, and that's what you would reference here. Many counties now, unfortunately, are requiring a copy of this trust, and I'm sorry to say our trusts are wordy, and so sometimes they're kind of long, but that they're requiring it. So Gwinnett County for sure is. You could always just include this language we have here, and then if the court wants it, they'll ask for it. But Gwinnett, and I think most of the time in DeKalb, they're asking for those trusts. So you could also just submit it. And then again, was any other document created which gave another individual authority to act on behalf of the proposed ward? Again, usually that's no. Does any other person have authority to act on behalf of the proposed ward? What the court's looking for here is there a power of attorney out there somewhere that's appointed an agent that might conflict, has another guardianship and appointed somewhere that might conflict? What's going on? So almost always those are going to be no. And then, does anyone named above have a financial conflict of interest with the proposed ward? And we have no here. Most of the time people are trying to do the right thing here, at least in our circumstances, and so the answer would be no. The other question here is, has an emergency guardianship been filed? And usually that's no too. Of course, if it's been filed, you want to put yes. Again, no emergency guardianship was established. On behalf of the proposed ward, a petition for guardianship and or conservatorship was created. Again, no, because this is the first time all of this is happening, right? This is basically the court just trying to get the background on all of this. Okay, so here we come to the conservatorship portion of the document. If your child has a bank account, like we were talking about, if they have income coming in other than Social Security, then you will need to file for conservatorship, and so you won't include this NA, filing for guardianship only. The only time we're filing for guardianship alone is if there's no bank account except for Social Security, if your child's receiving Social Security, that's when we can leave conservatorship out of it. It is a good idea to avoid conservatorship if you can. Because there's a lot of reporting requirements that come with conservatorship. So if you're granted conservatorship, you You have to file an annual return. You have to file an inventory and a plan for spending, and then you have to stick to the plan for spending. So if you can avoid it, it's good to do. You know, sometimes you just got to do it, and so it goes. If you do have assets, you would list them in here. Again, you can see real property. That would be a home or some other actual piece of property. You've got the income. So if your child is working and earning income, then that would come in here. You can see we've got the Social Security listed, and the court is going to want to know that the person is receiving Social Security and who the representative payee is. Otherwise, they will ask you in the process, are you aware that if you get Social Security, you've got to get a representative payee, and they'll talk about that. All right, so Angela's asking an excellent question, which is a stable account listed here? Is a stable account needed for conservatorship? Very good question that I wish I could give you the answer to. So able accounts are new, relatively new. And the answer is it depends. Fulton County has determined that able accounts do not qualify as a conservatorship asset. So if you're filing in Fulton County, then you would list it, but you don't need to apply for conservatorship. Pretty much in any case, you're going to list the able account to disclose it to the court. I hate that I don't have a good answer for this, but I don't. In most other counties, we're making the argument on behalf of our clients that an able account does not qualify as a conservatorship asset, but the law is ambiguous, and this is something that they need to work out. The biggest problem what we're finding is that it depends on what able account program you jump into. So it looks, Angela's referencing stable, which is a Georgia account, I think at least. Georgia's is called stable. And from what I can gather, you don't need conservatorship for Georgia's able account program. Now, again, it's very county specific, and right now we're still kind of fighting it out a little bit with counties and trying to prove that, yes, in fact, this is not a conservatorship asset. I've had some other clients who have other accounts through different programs, and those programs, we had one recently that required a conservatorship in order to access the money. So, you know, it's something you could file for a limited guardianship and move the money out of an able account, but an able account is a great tool for a lot of circumstances. So it may be one of those things where, depending on the program you're in, you may have to have conservatorship. But the way I would approach it, if that's the only other asset that your child has is the able account and maybe Social Security, is to approach it as if you do not need conservatorship. Something else to know. If you anticipate your child will be working at some point, maybe they'll start earning some income at some point, then what you want to do is say, no, we don't need conservatorship now, but you want to ask the court to find that your child meets the standard for conservatorship, so that if you ever need to go back to the court because you've got income coming in or whatever else happens, then the court has already made the finding that your child meets the standard for conservatorship, and they don't have to go through quite the same kind of rigmarole. All right, so here's where any of the assets that don't apply here, you of course would just leave blank, or you'd write NA. And then down here is where you list out kind of a budget for your child. So again, this is only if you need conservatorship. Only if you're applying for conservatorship would you fill any of this in. Otherwise, you leave it blank. You can write NA. This is where you're kind of creating a budget. So you're telling the court, this is how much we spend, this is how much we're going to keep spending. So you want to do this. You don't want to be lazy about this, because if somehow maybe you're spending more than you put on here, the court's going to notice, and it's going to be a headache. Okay. Again, almost always, in most people's cases, a guardian ad litem, you can see in this paragraph 11, is not necessary. Remember, there's two different attorneys at play here. So the court's going to appoint an attorney for your proposed ward. That's always going to happen. Then there may be a guardian ad litem appointed, another attorney, in very limited circumstances. That almost never applies. It's ones where you should have an attorney. So if you needed a guardian ad litem, you should definitely get an attorney. But they're kind of crazy situations, like if the conservator's trying to get extra powers to do some big things or something like that. All right, and then you can see we want to prove to the court that the proposed ward was living in Georgia, really, for 6 months prior to filing the petition. So if they were in another state for 6 months prior, then you would need to hit yes, and that would be a little bit limiting as far as the proposed ward needs to be in Georgia for 6 months prior to filing this. Again, you just answer all these questions. Did the proposed ward live alone? And explain all of that. And then here we've got some sample language for the court has jurisdiction to hear this action because the proposed ward is domiciled in the county, right? So we're giving the court information about the jurisdiction, and you can use that language there. And then if you have two petitioners, both would sign and they would provide all of their information. You want to continue on and do this verification. So this is the part I was talking about with kind of saying everything is accurate. So we want to make sure that we do this and we tell the court, yes, it's all valid and true. Assuming there's two petitioners, both would sign, and then you're going to get 2 stamps by a notary, right? So the notary can't just sign one time for both signatures, you got to sign twice. And then you would have the person who is the proposed guardian sign this consent to serve as a guardian. This does not have to be notarized, so it can just be filled out. If you've got a guardian and conservator, then of course the conservator would fill out this here. Okay, and then basically from here, this is going to be unnecessary. You do not need to complete this. Assuming that you have 2 petitioners, this is the affidavit that the doctor would sign if you had 1 petitioner and the affidavit. So you can skip that. And then this page you can leave blank. This is we've got the information up here, but this is going to be what the court will send to the people that are being served the petition, those 2 adults, and they will the court can get this signed. And so that's all those people have to do is sign this page. They do have to get their signature notarized, but it's pretty simple. You can have those people sign this ahead of time, but and sometimes that can kind of speed things up a little bit, but the court will get it done. And so that's one of those things where you can decide. It's the same heading as the first page we talked about, and then you would just fill in the person from paragraph 6, person from paragraph 6, and then make sure each signature gets a notary on it. Again, you can't do 1 notary for multiple signatures. Okay, so that is the petition. And basically what happens once you submit the petition, again, is that the court kind of kicks in with this series of appointing an evaluator, appointing the court-appointed attorney, and assigning a hearing date. And the hearing date is going to be, again, somewhere in the range of usually 6 to 8 weeks from the date of filing. The court will let you know. Right now, all the courts are doing the hearings virtually. And I hope that continues. I know from our end of things, at least, it's been great because you don't have to leave the house. It's a little bit less pressure. Of course, we want to make sure that we don't have any technical difficulties. The judges can get a little frustrated with that. But I would expect that these hearings will be virtual for probably the remainder of the year. And I've been hearing from DeKalb and Fulton that they want to continue doing them virtually. So the court-appointed attorney is going to be the person who will decide whether the proposed ward has to participate in the hearing. By and large, there's never an issue. So if you, generally the court-appointed attorney will contact you a week or 2 before the hearing. You can always reach out to them in the meantime, but they'll usually contact you a week or 2 before the hearing. They often want to try to talk to the proposed ward, and they get it. I mean, these hearings are usually kind of difficult for the proposed ward because you're just listing out all of the things that they need help with or they have some struggles with. And so we almost always waive or request that the court-appointed attorney waive the proposed ward's appearance at the hearing. Ultimately, it's their decision. So I have had some that say no for whatever reason, but by and large, they'll waive appearance if you want them to. And now some proposed wards want to be involved, in which case they have a right to be in, and maybe they should be. So that's something to think about. At the hearing, you're basically going to be regurgitating all of that paragraph 3 that we talked about. You're going to want to explain to the judge, you know, here's where we live, right? You want to give jurisdiction, and then you want to say, here are any health diagnoses that we have. Here are the ways that disability manifests. Here are kind of some evidence as to why this person needs help, because of course, disability does not equal guardianship, right? There's all kinds of ways that a disability can manifest. And so we want to give some pretty concrete examples. And when we're doing this, we go through and ask a whole bunch of questions about things like, you know, the clothing. Do they know how to wear a coat if it's cold outside? Are they showering? Are they safe in public? And just go through all of those things. And so that's what the hearing will be. Almost always the hearing is going to be it's pretty easy as far as legal proceedings go, but it's still a formal hearing. Both petitioners do not need to appear. In fact, the only person that needs to appear at the hearing is the person who is going to be, well, I take it back. If you've got a petitioner if you've got 2 petitioners and then separately the guardian, then you would want to have one of the petitioners and the guardian appear at the hearing. But usually one of the petitioners is also the person who is going to be serving as guardian. And so that is the person who really needs to show up at the hearing. Again, the proposed ward, you want to kind of operate under the assumption that they have to go until you talk to the court-appointed attorney. And again, that's the person that will decide about whether they have to appear. And you just want to say, will you please waive their appearance? And you can explain why. And again, usually they will. So if you've got, for example, 2 people who are petitioning and you're not petitioning for co-guardianship, then just one of them has to appear, the person who's going to be the guardian. I'm trying to think if there's anything else before we kind of open it up for questions. I'm going to stop my screen share. That's really all I have from the petition side of things. Are there any other questions in general about the process? Or the other thing to know is that once you get appointed as a guardian, which usually happens the day of the hearing, the court says, okay, I grant this. You don't necessarily get the letters right away, but you can get that verbal, okay, we're granting this. You have to submit what's called a personal status report. The court will provide you with that within 60 days of the hearing. And that's just kind of getting information to the court. So, you know, what's the phone number and address of the proposed ward, give us a little bit of information, and they'll keep that on record, and then you have to file that yearly. Yes, if you've got 2 people petitioning to serve as co-guardians, both of them should appear at the hearing. The only time you would have both petitioners don't have to appear is if only one of them is petitioning to serve as guardian.
Laura, to get to the second half of that previous question, the person's notified on behalf of the individual who is the proposed ward. I know they have to get that signed and notarized, but are they at court at all? Can they show up if they'd like to?
They can show up if they'd like to, but again, because most of these are virtual, and frankly, I anticipate that unless you live in a really outlying county, they will likely continue to be virtual. And so, no, the only person that has to appear at the hearing, or people, are who is going to try to be appointed as a guardian or conservator. Which is nice, because the hearing can be, especially if we have to go back to going down to the courthouse, it's, again, not a huge deal. The hearing itself is not a huge deal, but you are having to go down to the courthouse, go through security, park, all this stuff. So the virtual is good. Any other questions?
If y'all would like to unmute, feel free, or, you know, I'll give you all another minute or 2 to just put some questions in the chat. But in the meantime, Laura, thank you for doing this today, for walking our families through all this and giving us all this great information. It's greatly appreciated.
This is our pleasure. it's nice to be able to connect in some way these days.
And if someone wants to get in touch with you after this, what would be the best way to do that?
So I'll put it in the chat box. You can go to our website, which is nadlervirna.com. You can call, I'll put our phone number in there, and we've got all this on the materials, I think, too, but that's our phone number. You can call or go to our website. There's a bunch of information on our website, too. And so either of those options are good. And of course, if you want, if you just have questions, you can call or check out the website. The website has a lot of information. Debbie's asking, if I do co-guardianship but then decide it's too hard, how can I change it to just one person? You have to have that person go to court and petition the court to resign. So unfortunately, it's one of those things where guardianship, I mean, it's a big deal, right? So we're taking someone's rights away, their fundamental rights. So unfortunately, the court is pretty involved in the entire process. So even after, like I said, you've got that yearly reporting requirement to the court, even with a guardianship. So, so if you do co-guardianship, that's going to be another kind of added court connection, because the person who, if you're thinking, it's just too much, we just need to go back down to one. Well, in order to do that, you're going to have to petition the court. And depending on what court you're in, that may or may not be a fun, well, it will never be a fun experience, but some of the judges in the metro area, well, I'm not going to name any names, I'm going to be diplomatic, but something to think about is just that because it's a big deal to be appointed as guardian, they're not going to, they'll grant your request almost definitely. They're not going to force you to serve as guardian, but they're not going to look kindly on it. So something to think about is, what are you getting into? Do you really feel like both people are going to be available or ready to go? And just kind of, I would think on that before trying to go back and fix it.